0058, toll free 1-800-329-5858. My guest today is attorney Jim Monroe. He's a bankruptcy attorney. So Jim, let's just start with the basics, and that is this. In the Florida Chapter 7 bankruptcy, who qualifies to file a Chapter 7 bankruptcy?
Well, nationally in 2005, Congress amended the bankruptcy code, and certain individuals cannot file a Chapter 7 anymore. And there are all kinds of little hurdles that you have to go through, but basic hurdle is the means test. You take a look at an individual's income for their family size and subtract out some expenses, and if they have excess income after all those expenses are subtracted out, they simply don't qualify for filing Chapter 7.
And of all the clients that come to you that think in terms of needing a bankruptcy, and let's just say they actually do need a bankruptcy, what percentage of them would like to do Chapter 7 bankruptcy, and what percentage of them actually qualify to do Chapter 7 bankruptcy?
Well, I'd say about 80 to 90% do qualify for Chapter 7, but there are reasons why you would want them to go into a Chapter 13 sometimes as opposed to a Chapter 7. And that has to do with saving property, dealing with a tax situation, dealing with a mortgage modification, or stripping off the second mortgage on a home and things like that.
Well, who is your typical bankruptcy client these days, and how did they get there?
Well, they got there primarily because of the economy and the fact that they've lost a business, lost a job, have become ill, and of course there's the old reasons like divorce, and any type of economic disruption will send a client into a bankruptcy attorney's office.
And most of the clients that come to you, I'm going to assume that the only piece of property that they own is the home they live in, for the most part, right? And they have some retirement accounts.
Right.
And they probably have a lot of debt.
That's right.
And so would that be a Chapter 7 candidate for a client?
Well, as long as they meet the qualifications under the means test. As you know, when a Chapter 7 case is filed, a Chapter 7 trustee is appointed, and they can take certain property to be liquidated for the benefit of your creditors. Now, to tell you the truth, most people who file Chapter 7 don't lose their home, they don't lose their personal property, or they can make arrangements to keep everything. But under Florida law, for example, a person's homestead is their castle, so the trustee cannot liquidate somebody's homestead. And household goods and furnishings, they just don't want to take because nobody is buying secondhand furniture. The third thing is qualified retirement accounts such as 401ks, IRAs, and annuities, which are used for retirement, are not something that can be liquidated for creditors. In other words, the debtor gets to keep all that property.
And then the other thing people typically own is a car. So what typically happens with somebody's car when they file a Chapter 7 bankruptcy?
Most people are upside down in their automobiles when they file a bankruptcy. That is, they owe more on the car than what it's worth. But if they have equity, you're allowed $1,000 equity per person, which means in a family, husband and wife who file, they get to exempt out $2,000. And if they're a little bit over that in equity, the difference between the value of the car and what they owe on the car, generally a Chapter 7 trustee will take some payments over time or make some kind of arrangements so that they can keep their car for going back and forth to work.
So if we talk about a car that's upside down, a typical client comes in and sees you, and they have a car that they owe $20,000 on. The car is only worth $15,000. Would your typical client keep that car or give it back to the bank?
Well, if they owe 20 and it's worth 15, it's up to them based upon their budget whether or not they want to continue with the automobile or whether or not they want to surrender it to the bank. If they surrender it to the car finance company or the financial institution that has financed it, the debt goes away. And if they want to keep the vehicle these days, they may have to reaffirm the debt, and that is tell the finance company that they want to keep the debt and the car.
Would a reason for them to keep the car, even if it's worth 15, they owe 20, would be as if they give it back to the bank, it would be difficult for them to go buy another car once their bankruptcy is finished?
That's a hard question to answer these days because the way that the market and everything is working, I've never had a client come back and tell me they couldn't secure other transportation if they gave back a vehicle, but that is a concern.
All right. And so then let's talk about the house, because a lot of people must come to you these days and they're upside down in their house, meaning that they owe more than what it's worth. If they were to file Chapter 7 bankruptcy, would the end result of that would be that they would simply give the house back to the bank and they would move out?
If they wanted to give the house back to the mortgage company or the bank, they could, and they could move on, and there would be no deficiency judgment later on. And a deficiency judgment is when the bank sells it on the courthouse steps and the value of the property is far less than what you owe on the mortgage, and usually they can continue to pursue you for the difference.
And so then, again, we're talking about a lot of people being upside down in their house. They owe more than what it's worth. Is that a reason for you to move them out of Chapter 7 and into a Chapter 13 reorganization?
If they are behind on their house, that is, and they want to keep it, that is one of the reasons to move them into a 13. We can, under law, if they are far upside down and they have a second mortgage, for example, strip off that second mortgage. And in Chapter 13, we now have a mortgage modification program that is very successful.
All right. Well, Jim, I think on the other side of the break, we want to dive into this Chapter 13 reorganization for people who are filing bankruptcy and are upside down in their house. I want some more detail about that. Folks, I want to remind you that during this radio show, you can call at any time with a question or comment about what we're discussing. Today is bankruptcy. Or you can call at any time to brag on your lawyer and tell us how he or she gave you a great client experience and how they give back to the community. The phone numbers are 407-290-0058, toll-free 1-800-329-5858. And remember, when you call to brag on your lawyer, I will call him or her and invite them to a restaurant of their choice to honor that lawyer. If you want to see some pictures of my lunch with lawyers, go to 11lawyers.com or check us out on Facebook on our page at 11 Lawyers Radio Show. That's 11 Lawyers Radio Show. Hey, folks, I want to remind you that Monday through Friday, 9 to 5, the lawyer's at my office, and that is the Olsen Law Group. We are always happy to give you a few minutes of free legal advice right over the telephone. Monday through Friday, you can reach the Olsen Law Group at 407-423-5561. And you can always email your legal questions to us through our Olsen Law Group website, and that is olsenlawgroup.com. My name is Tom Olsen. The name of the show is... Welcome back, everybody, to the 11 Lawyers Radio Show. I am attorney Tom Olsen, your host. I've been a lawyer in Orlando for 30 years, and I've been answering your legal questions on my Olsen on Law Radio Show for 25 years. And, folks, that adds up to about 1,400 radio shows and 20,000 legal questions that I've answered on the air right here in Orlando. As part of the 25th anniversary of my Olsen on Law Radio Show, I am committed to building a law knowledge center and video law library. To help me do this, I've started this new radio show. I've named the show 11 Lawyers Radio Show because I want you to quickly understand that it will take many attorneys to help me build the Law Knowledge Center and Video Law Library. Follow our progress at 11lawyers.com. On this show, I want to also give recognition to Central Florida attorneys who serve justice, their clients, and the community. So on this show, I invite you to call and brag on your lawyer. Tell us how he or she gave you a great client experience and gives back to the community. To honor the lawyer, I will invite him or her to lunch at a restaurant of their choice. See pictures of my lunch with lawyers at 11lawyers.com or on Facebook at 11 Lawyers Radio Show. That's 11 Lawyers Radio Show. Last week, I had the pleasure of having lunch with 3 attorneys. Sean Smith, who was talked about by Rufus, Jack Kalita, attorney, and attorney Bill Umansky, and all great 3 lawyers, and but for you recommending them to us, I would not have had the pleasure of meeting them, so I'm thoroughly enjoying that. Next week, I have lunch with Tom Sadaka and attorney Tom Callan. My guest today is Attorney Jim Monroe. Our focus today is bankruptcy. And so, Jim, we have talked during the first half of the show about the chapters of 7, 13, and 11. I know that 11 is for business, so we're focused on individuals today. So give me quickly, what is the difference between a Chapter 7 bankruptcy and a Chapter 13 bankruptcy?
Chapter 7 bankruptcy is a bankruptcy where you're in and out and you're trying to discharge your unsecured debts and deal with maybe giving secured property back and cleaning off the debts. Chapter 13 is for those individuals that don't qualify for Chapter 7, but also may have a problem like they're being foreclosed upon a house, or they're about ready to lose a car, they have a bad tax problem, so they want to restructure those debts over a 3 to 5 year period and make sure that they keep that property.
And so in a Chapter 13, let's just say that somebody came into a 13 and they had $100,000 in medical bills and credit card debt, so unsecured debt, right? When they finish their 13, will they still owe $100,000, but they get to pay it over time? Or does the court actually reduce the amount of their debt and let them pay it over time?
They actually only pay a fraction, whatever they can afford, on that unsecured debt. And usually we're focusing in a Chapter 13 on doing something different, and that is, let's say that your house is in foreclosure, or you want to do something with your situation where you're upside down in your house, or you're having some other types of long-term problems. And that's what a 13 is designed for, to help cure those problems.
So certainly these days, a lot of people are using a Chapter 13 when they are upside down in their house. And how could a Chapter 13 assist them if they were upside down in the house and I assume unable to make their payments?
Well, in the Central Florida area here, and also in Alabama and in Georgia, we're in the 11th Circuit, there was a decision that allows us to strip off a second mortgage when they owe more on their first mortgage than what the house is worth. So that second mortgage gets stripped off, and then we go to try to deal with the modification of the first mortgage. Well, we're not allowed to modify the mortgage by using the bankruptcy code. We do have a program here in the Orlando division started by Lori Weatherford, who's Chapter 13 trustee, and the judges, that has been phenomenally successful in modifying those mortgages and helping people keep their homes.
So I'm hearing two key things there, and that is Chapter 13 allows them to strip off the second mortgages, and that's where a lot of people got in trouble when their houses went up so greatly in value. All of a sudden they have these huge equity lines available to them. Those, in certain circumstances, under Chapter 13 can be wiped out.
That's correct.
And then what you're telling me as far as Chapter 13, the actual law itself, there's nothing within the 13 that can force a bank to modify the first mortgage terms, but in fact it's being done.
Yes, it is, and they modified the HAMP regulations back in November of 2010 to specifically mention Chapter 13 bankruptcy and to have regulations that apply to Chapter 13.
And so when you are doing a Chapter 13 for a client, there's still a trustee involved, I assume, right?
Yes, and that's a Chapter 13 trustee whose job is mainly just to collect and disperse to the creditors.
Well, whose job is it to negotiate with the first mortgage lender to modify the terms? Is that you or the trustee?
That's the debtor's attorney's job, and typically what we do is we would move for mediation and take it immediately into a mediation where the court would issue an order requiring the first mortgage holder to negotiate in good faith based upon the HAMP regulations or other internal regulations or programs that the bank has or the mortgage company has.
Would that be true even if the homeowner is not in default yet and a foreclosure has not yet been filed?
Yes, you can even try and get that accomplished. Even if they're current on their mortgages.
And so then, in your experience in these Chapter 13s and modifying first mortgages, what's available to them is a lower interest rate, a reduction of the principal amount, and an increase in the number of years the loan is amortized over. What's typically being accomplished with a Chapter 13 bankruptcy?
Well, that is, of course, part of the negotiation process, but it is true that I have seen in Chapter 13 a reduction of the mortgage balance, restructuring or lowering of the interest rate, and even an adjustment of the terms so that the debtor can afford the home.
All right, very good.